Too often, the stories we have to talk about in the world of Second Amendment rights are frustrating, filled with setbacks, filled with new restrictions, and filled with governments trying to chip away at freedoms one regulation at a time. But not today. Today is different because today we get to talk about a double victory, two separate rulings that came down almost simultaneously, and both represent important wins for the constitutional rights of ordinary Americans. It's not every day that you get to celebrate two court decisions back to back, but that is exactly what we have here. And when that happens, it deserves more than a passing mention. It deserves a deep dive into why these rulings matter, what they mean, and how they remind us that the fight for liberty is still alive. The first ruling out of New York set the tone, but I want to carry that momentum straight into the second ruling because it strikes at a pressure point that has throbbed for years. We head down to Florida, where a challenge targeted the federal prohibitions in 18 U.S.C. Sections 922 days, 3 and 922, G3 provisions that brand certain citizens as unlawful users of controlled substances and then treat that brand like a permanent disqualifier. The people at the center of this fight were medical marijuana patients following their state's laws and their doctor's guidance, not fugitives, not traffickers, not violent offenders. Yet the federal rule treated them as if they had stepped outside the circle of constitutional protection, as if one entry in a statute book erased a birthright. At the trial level, that label did most of the work. The suit was tossed before the facts could breathe with a conclusion that these patients were not law-abiding and not among the people the Second Amendment protects. That tidy reasoning might satisfy anyone who thinks rights are only for the spotless and the favored, but that has never been the American tradition. When the case reached a three-judge panel in the 11th Circuit, the judges did what courts should do. They pressed on the government's assumptions, they asked what the history actually shows, and they refused to let a vague descriptor do the heavy lifting where evidence and tradition were required. The panel looked at the record with clear eyes and said, at most, the complaint describes misdemeanor conduct under state law, not a felony, not an act of violence, not proof of ongoing dangerousness. Where is the historical tradition of disarming citizens for nonviolent misdemeanors? Where is the founding-era analog that lets the government strip a core right because a person uses a medicine their state recognizes? The answers were as thin as smoke. And when the government leaned on the word responsible, the judges pointed to the obvious problem. If responsibility is whatever an agency says it is this week, then anyone can be labeled irresponsible tomorrow. That is not how constitutional categories work, and it is not how liberty survives. Equally important, the panel drew a bright line that ordinary people instinctively understand. There is a world of difference between punishing dangerous conduct in the moment and disarming a person every day of the week, because on one day they might follow a medical program with their doctor's guidance. No one is blessing the idea of handling a firearm while impaired. That is wrong. And the law already has tools to address it, just as it does with driving under the influence, because the danger is immediate and obvious. What the government attempted here was different, a sweeping status ban that treats a patient's medicine like a scarlet letter, and that turns a temporary condition into a permanent forfeiture. This matters not only in doctrine, but in the lives of neighbors, Parents who come home tired and still need to walk to their cars at night. Veterans who manage chronic pain and still want the same means of self-defense everyone else relies upon. Patients who did exactly what their state allowed and what their physicians recommended. Telling them to choose between relief and self-defense was always a cruel choice, the sort of blunt bureaucratic order that forgets there are human beings on the other end of the policy. The panel's reasoning says plainly that the Constitution does not tolerate that kind of casual disarmament. Set this Florida ruling beside the New York ruling, and a larger picture comes into focus. In one, we are told that your rights do not stop at a state line because a residency rule prefers locals. In the other, we are told that your rights do not evaporate because you follow a medical program your state authorizes. Both opinions point in the same direction toward a charter that binds officials as surely as it binds citizens toward a civic culture that treats self-defense as a sober responsibility rather than a favor dispensed by a licensing office toward a judiciary that insists on history and principle instead of buzzwords and paperwork. So, let this sink in. There will be new fights, new headlines that make your teeth grind, and new attempts to dodge the merits with clever procedures and moving targets. But tonight, this is a double victory worth savoring. It proves that persistence matters, that good arguments win when courts demand real history instead of hollow slogans, and that ordinary people who keep showing up can still move the needle. The road ahead will not be smooth, but it will be lit by decisions like these steady lights in a landscape that has too often been dimmed by fear and fashion. And through it all, the lesson endures: know the law, carry yourself like a lawful and responsible citizen, and never forget that constitutional rights do not fade at state borders or under bureaucratic labels. The Florida development deserves a close look because it shows how quickly labels can become shackles if courts stop insisting on history and principle. The federal provisions at issue Title 18 U.S. Code sections 922d3 and 922g3 draw a circle around anyone the government calls an unlawful user of a controlled substance, and then treat that status like a master key that locks every door. The plaintiffs were medical marijuana patients following a state program and doctors' guidance, not gun runners or violent criminals, and yet the federal rules spoke as if a word in the statute book could strip them of a right that predates the statute, the agency, and the regulatory state. That is how the word unlawful gets weaponized. It becomes a shortcut for suspicion, a way to paint with a bucket instead of a brush. And if courts let it happen, the bucket will never run dry. So Florida became the place where that shortcut finally met a speed bump. At the trial court, the syllogism carried the day: marijuana remains illegal under federal law. Therefore, anyone who uses it is not law-abiding. And if one is not law-abiding, one is outside the circle of the people the Second Amendment protects. The case was dismissed before it could breathe, with no discovery and no chance to test the government's narrative against facts. But on appeal, a three-judge panel in the 11th Circuit did what a court following the text and history standard must do. It stepped back from the label and asked whether the Constitution's promise can be undone by a category that would have baffled the founding generation. The panel examined the complaint in the light favorable to the plaintiffs, because that is the rule at the motion-to-dismiss stage, and it asked a question the government could not answer with evidence or tradition. Where is the historical analog for disarming citizens on the basis of nonviolent, misdemeanor-level conduct that a state permits under its medical program? The record came up thin. Pointing to 20th-century experiments and modern anxieties does not substitute for the kind of tradition the Supreme Court has told us to look for. The text covers ordinary citizens who wish to keep and bear arms for self-defense, and the government bears the burden of justifying a restriction by pointing to a well-established historical practice. Vague labels like responsible or not responsible do not carry that burden, because those words can be stretched to fit anyone the government dislikes tomorrow. The panel recognized another distinction that matters in real life. It is one thing to ban handling a firearm while actually impaired, because that danger is immediate and specific, and it is another thing entirely to impose a status-based disability that follows a person home to work, to the grocery store, and to the parking lot at night. One rule punishes conduct, the other cancels a right. Anyone living with pain or anxiety knows what that cancellation looks like. A parent follows a doctor-guided treatment to sleep and then learns the price is walking to a dark car without the protection neighbors may lawfully carry. A veteran keeps nightmares at bay with a state-approved regimen and is told a federal label makes them presumptively untrustworthy. The message from the 11th Circuit was overdue. The Constitution does not tolerate casual disarmament built on stereotypes and status. Rules against intoxicated carrying can and should remain. They target a concrete danger. But turning a medical program into a mark of suspicion does not match our historical tradition and cannot be squared with a charter that binds government, not empowers it to sort citizens into favored and disfavored camps. Set the Florida result beside the New York ruling, and the line becomes obvious. One jurisdiction tried to end rights at a border, the other tried to end rights at a pharmacy counter. Both met the same answer: the Bill of Rights is neither a residency club nor a morals tribunal. When courts demand history instead of maneuver and refuse to let temporary tweaks moot controversies, the dust settles and the text speaks. The people means the people, and the right to keep and bear arms does not expire at a county line or clinic door. None of this guarantees an easy road. There will be motions for rehearing, petitions up the line, and new bills drafted to test the limits again. There will be noise and attempts to rebrand old restrictions with new slogans. But the lesson is steadier than the noise. Persistence matters. Careful lawyering matters, and fidelity to the Constitution wins when courts insist on it. For travelers who refuse to become defenseless because a sign marks a new jurisdiction, and for patients who refuse to choose between medical relief and the dignity of self-defense, These decisions are not abstractions. They are oxygen. And for everyone who felt we were getting punched in the mouth and kicked in the shins, this is the reminder we truly needed today. The ground can move our way, and when it does, it is because we stood our ground first for good. Taken together, these rulings feel like fresh air after a long season of holding our breath. They bring clarity. Wins like these steady our hands and remind us that perseverance, not panic, moves the needle toward liberty. They tell officials who govern by label and loophole that courts still demand history and principle. When did this country accept the idea that a right dies at a border or at a pharmacy counter? A republic preserves liberty by limiting government and honoring tradition. After weeks of being told to accept less, we see decisions that insist on honesty, rigor, and respect. Listen to the rhythm across both opinions. In New York, the line was geography apply only if you live here or plant your business here. In Florida, the line was status, lose your right because of a medical program your state permits. Different tactics, same end disarmament by category. The courts pushed back. They reminded us that the Second Amendment speaks about the people, not the preferred, and that the core is ordinary self-defense. No border should erase it, and no bureaucratic label should dissolve it. History did not support these limits, and the effort to nibble a birthright stopped. There will be rehearings, petitions, and headlines. Bureaucracies do not surrender ground easily, and they search for new packaging when the old wrapping tears. Even if the road bends, precedent and principle mark the way. Expect phrases for old prohibitions, pilot programs meant to moot cases without fixing anything, and claims that rights are privileges earned through paperwork and fortune. We have seen those plays before. The answer stays the same. The Constitution binds the government, not the citizen. Courts test power against principle and insist that policy yield when it collides with rights. That remains true in hard seasons. None of this diminishes the responsibility that comes with the right. It heightens it. Being a lawful and responsible gun owner means knowing the law, storing and carrying safely, and refusing to mix firearms with impairment. These decisions do not bless recklessness. They condemn laziness in lawmaking. They tell officials to punish dangerous conduct and to stop treating citizens like problems. That balance matters. It is how communities stay safe without pretending that safety and liberty are enemies. When neighbors exercise rights with calm discipline, caricatures collapse, and the case for blanket bans weakens. Freedom thrives when practiced with care. So, where do we go from here? We keep showing up. Read the opinions, learn the rules, and hold officials to constitutional standards. Challenge policies that wall off rights with residency tricks or status badges, and support reforms that streamline lawful carry, improve training, and close gaps. Tell the truth when headlines get it wrong and stay patient when the process grinds. The other side counts on fatigue. Answer with disciplined persistence. Local elections matter. State legislatures matter. Appointments matter. When we show up consistently, temperatures drop dramatically. The law steadies and rights stop sliding like furniture in heavy seas. I am grateful for everyone who cares enough to follow along, to think hard about these issues, and to speak up in good faith. If you found this helpful, let me know by sharing your thoughts, by passing this to someone who needs a lift, and by sticking around for future conversations. Your questions shape where we go next, and your stories remind me what is at stake. We have taken some hits lately. Tonight we can say we landed a few punches of our own, and it feels good. Let that feeling fuel patience, work, and courage and resolve. As always, stay informed, stay safe, and carry yourself with the humility and seriousness that freedom requires. Read the law. Respect the law. Be the kind of neighbor who makes liberty look responsible, calm, and steady. Remember this truth: a right that depends on a border or a label is not a right at all. Rights live in the people. Hold fast to that, hold fast to one another, and keep walking forward with eyes and a level head. I will see you soon as we keep telling the truth one case at a time until officials remember their oaths. https://print.sc/nlawc17 whttps://print.sc/urion9 guqjdcb bauttps//print.sc/qvpvketi 3si4bv